All right, so now we want to take a look at some dual agency issues when it comes to these fiduciary duties that we talked about the 6 fiduciary duties in the last hour that the that the agent owes to the client. But if you're in a dual agency situation, now remember, if you're dual agency means you're representing both the buyer and the seller in the same transaction. If you have a dual agency, then this is going to change a little bit in terms of what the agent owes to the principal. And y'all, you've got to make sure you explain this to both the buyer and the seller. Y'all, this is part of the information the principal needs to know in order to make a decision on if they're okay with dual agency or not, okay? Because things are going to change up a little bit. So basically what you would have to tell both buyer and seller, if dual agency is going to be an option here, that of the fiduciary duties, the 6 fiduciary duties that I owe to each party, 3 of the 6 become limited. Now I still owe all 6, but again, three duties are limited. And I would remember what these 3 are. And you see them listed here, but the first limited duty is obedience. Buyer, seller, I will be limited on how much I can obey on what you tell me to do or not do. And look, and here's really the gist behind these limitations. For example, obedience. Buyer, you can't tell me to do something that's going to hurt the seller, because the seller's also my client under dual agency. Seller, you can't tell me to do something that's going to hurt the buyer. I can't do that. In other words, I can't do anything for one party that's going to hurt the other party, because I'm representing both parties under dual agency. So you got to be careful about that and make sure both parties know you're going to be limited in some of these situations. Loyalty obviously is limited. Because now with the loyalty, my loyalty is split between the 2 parties. Now you both are getting the exact same amount of loyalty, but it is going to be limited because I've got 2 clients here. And then the third one that's limited is disclosure, which is obviously a biggie. I will be limited on what I can disclose to either or both parties. You know, for example, when I listed that house for sale, seller being my client, is it possible the seller said, all right, well, let's list it for $300,000. But if I get an offer for $290, I'll sell it for that. But that's the lowest I'll go is $290. Now, y'all, obviously the reason the seller's telling you that is they would prefer to get to $300, right? But the bottom line here, the lowest they're willing to go is going to be $290. Y'all, you kind of need to know that when you're negotiating. You got to know what your parameters are. Otherwise, you don't know how to negotiate. So even though I've listed it for $300,000, I know that potentially the seller will sell it for $290. Well, can I go tell my buyer, hey, look, I know they're asking $300, but they'll sell it for $290. Make an offer for $290. No, you can't do that, because that hurts the seller. So you're going to be limited on what you can disclose or how much you can disclose. So obedience, loyalty, and disclosure. Those 3 duties become limited. And the only reason they're limited, and the way I like to explain it to my clients, is just that I can't do anything for one that's going to hurt the other. In no way will I do anything for either one of you that's going to hurt the other party. Not going to happen. Not going to do that. Now, the other 3 duties you still continue to provide in full. Obviously the confidentiality, accounting, the reasonable care and due diligence. Those 3 you provide in full. But you would do well to remember the 3 duties that are limited if you're in a dual agency situation. Okay? All right. So now we look at what are the principals, what are the principals' obligations to the agent? Because they owe us something too. And these are legal obligations. So let's take a look at what those might be. Obviously, number 1 is compensation. And obviously the compensation will be whatever was agreed upon. So, seller, if I list your house and you agreed to pay me 7% commission, once it sells, then you owe me 7% of whatever it sold for, right? And by law, seller, you got to pay it. That's what you agreed to. Now, you'll also notice in this last bullet on the slide, obviously it's in your book as well, but I was talking about this procuring cause, the procuring cause of sale. That could be important to you down the road, certainly when you're practicing real estate, but I can assure you it'd be important to you for the test. But here's where procuring cause can become an issue. Y'all, let me just give you an example, and I will tell you this kind of stuff happens, and it's pretty common when it happens. But let's say I'm working with a buyer. In fact, the buyer is my client. They have signed a buyer agency agreement. The buyer is my client. I've shown them house after house after house after house. And if you're going to be working with buyers, just get ready. It just seems like buyers, they want to go look at every single house in town, and maybe a few outside of town, before they'll decide on what they like, if they like anything. But anyway, let's say I've shown them all these houses, but we finally get to this last house, and the buyer, as we're walking through, the buyer says, "Frankie, this is it. This is what I've been looking for. This is it. I love it. I want it. Let's get it." All right. I got to be honest with you. I've been doing this a long time, and when I hear them words, I still get excited. And I'm not sure whether the excitement is because of I'm fixing to get hopefully paid down the road, or I don't have to show this buyer any more houses. I'm not sure which I'm getting more excited about, but anyway. So obviously what the next step is, then we need to go ahead and make an offer. So I said, well, this awesome buyer, you ready to make an offer? And what are they going to say? More likely than not, no, I don't want to make an offer yet. Well, I thought you said this was it. You're in love with this house. You said this is it. You go, oh, it is. I'm sure this is the house we want. Okay, well, the next step is to make an offer. Yeah, well, I don't want to be rushed into anything. I need to sleep on it overnight or over the weekend or whatever. Okay, here we go. Y'all, look, if they don't want to make an offer right away, then you're just going to have to wait. That's all there is to it. So let's just say in this scenario, my buyer says, "Frankie, I'm sure we're going to make an offer. We love the house. But call me Monday morning and we'll get together and probably go and write up the offer then. But I just want to kind of sleep on it, rest, think about it over the weekend." Okay, well, if that's what they want to do, that's what they're going to do. Well, let's say on Saturday, my buyer is doing some shopping at Walmart, for example. And while she's at Walmart, she runs into a long-lost friend. They've been friends forever. They just haven't seen each other in a while. And they're just trying to catch up. And while they're talking, my buyer happens to tell her friend that she's actually looking to buy a house right now. And her friend goes, "Oh, really? Well, I'm a real estate agent. I'm a licensed agent. I can help you. It would be so much fun for us to work together." "Oh, yeah, that would be great. There's actually a house that I'm very interested in right now. In fact, if you're able, I'd love just to go look at it again. Because we really like this particular house. So they say, okay, well, you know what? You run home, put up your groceries, I'll put up mine, and we'll meet there. And we'll take a look at it again. Now, wait a minute now. This is my buyer. Keep that in mind. But anyway, so this other agent now meets the buyer out the same house, and they look at it. Now, after looking at it the second time, now the buyer has no doubts whatsoever. I want it. Let's move on it. So the buyer signs, or that new agent asks the buyer to sign an agency agreement so that this agent could represent them. You know this is going downhill fast. But anyway, so she signs another buyer agreement with this other agent, and then they go ahead and write up an offer. And for argument's sake, say the seller accepts the offer. Here we go. So then Monday morning rolls around, and I go, and as I was instructed to do, I called my buyer and said, all right, buyer, it's Monday morning. You had time to think about it? You think you want to make an offer? And the buyer said, oh, Frankie, I've got great news. Y'all, I've learned from experience, y'all, when the buyer, or quite frankly, seller, either one, starts telling me about all the great news they got, okay, wait a minute, let me find somewhere to sit. Because it usually winds up not being that great. Might sound great to them, but it's somehow, here I am getting the short end of the stick again. But anyway, Frankie, I ran into a friend of mine over the weekend. I find out she is also a real estate agent, and she took me out to look at the house again, and that's when I was sure we wanted it. So she went ahead and helped me make an offer, and the seller accepted it. Isn't that awesome? I'm like, really? Well, what about me? Okay. Look, so in a situation like this, look, there's only going to be one agent that's going to get paid a commission at closing. There's only going to be one agent. Two agents can't show up to closing and expect a check. There's only one. So the question is, in this scenario, who's due a commission? Would it be me? Or would it be her friend, the agent? Who's due the commission? And I will tell you, in a situation like this, basically that creates a dispute. Obviously, I'm going to say, no, look, I was first. She was my client before she was your client. I showed them how I should be getting paid the commission. Well, the other agent's going to have their argument too. Yeah, but I showed them the house also. In fact, I wrote up the offer. I should get the commission. So we have a dispute between two agents now on who should be getting paid this commission. Well, when you have a dispute, how do we determine who's going to get paid? Well, I will tell you, based on the law, whichever agent can prove they were the procuring cause of the sale, that will be the agent going to closing and getting paid. So how do you prove procuring cause? Well, to be procuring cause, you got to make sure you get this. This is important. To be the procuring cause, obviously you have to have an agency relationship in this case. But you have to have the agency relationship. You must have shown the property the buyer is buying. You have to show it to them. Write up the offer, negotiate the deal, and get the contract accepted, or what we refer to as ratified, set to close. Whichever agent can do all those things without any break in the chain of events. If something happens that breaks that chain of events, You start over again. But whichever agent can prove from start to finish, they got the agency agreement, showed the house, wrote up the offer, and got it accepted without any break, that agent is the procuring cause of the sale. So obviously, in this scenario I just gave you, sounds like I'm out of luck, because the moment my buyer signed another buyer agreement, agency agreement, that broke my chain of events and started a new chain, which that other agent took it from there all the way through getting contract accepted. So the other agent in this scenario would be going to closing and getting paid. Well, that kind of sucked for me, doesn't it? Well, am I due a commission? Yes, I'm still due a commission. The problem is I'm not going to get it at closing. Now, why am I due a commission? Because buyer, you signed a contract with me. And in that contract, y'all, I'm kind of paraphrasing a little bit, but in that contract, it says, if you buy a house that I showed you, you must pay me X amount of commission. It's under contract. The problem is I'm not going to get it at closing. So how am I going to get it? Well, one of two ways. Hopefully the buyer will say, all right, Frankie, yeah, you did do a good job, and I'll just write you a check myself for the commission. They could do that. Good luck. Good luck getting that check. But if they just don't write you a check, the only other recourse you have is to sue for it. To go to court and sue them. So then the question is, are you going to sue? Are you willing to lawyer up and go to court to get that commission? Now, we'll tell you at the end of the day, it will not be your decision to do that. It will be up to the broker in charge. And I can just about guarantee you, 99% of the time, you ain't going to court. You're just going to strike it up as a loss, and there you go. It kind of sucks when that happens, but I'm telling you, those kind of things are common. So, do you think the buyer was intentionally trying to hurt me, cause me damage? I don't think so. Not typically. I'm not saying that's the case for everybody, but I don't think they were trying to. But what I think happens here a lot, they don't know any better. So whose fault is it? It's my fault. At the end of the day, it's my fault. Because I was not clear when they signed the contract. And I'm telling you, I've been in these situations before where when I look back and kind of gained my composure back, it was my fault. You can't assume that your client knows what you know. So if you don't tell them, they don't know. They don't. So now I tell them point blank when they're signing this contract, do not sign anything with another agent after you sign this. Because if you do, you're going to be liable for 2 full commissions. In situations like this, the agents are not splitting the commission. You now owe both of us a full commission. Don't do that. So just in fact, you should not even be talking to another agent at all. Not during the term of our contract, okay? Every contract has a start date and an expiration date. But until this contract expires, you're my client. Do not be discussing real estate with any other agents. And for goodness sakes, don't sign anything with another agent, because it's going to come back and hurt you financially if you do that. If you don't explain that to them, I'm telling you, most people don't understand that or know that. So if you don't tell them, it's pretty much your fault. Another point I will make here, in this scenario example I just gave you, Anytime a buyer anytime you're talking to a buyer about buying, obviously, real estate, the first question out of your mouth, before you even engage in the conversation, the first question you should always ask every buyer, do you currently have an agent? Are you working with any other agents right now? Hopefully they'll say no, and then you're free to go. But from an ethical standpoint, you have an obligation to make sure before you have them sign a contract with you, you got to make sure they're not already under contract with somebody else. Again, you don't want to put people in situations where they could be financially harmed, right? So you got to ask, you got to ask that question. Hopefully they'll say no. Now, if they say, yes, I have, then your conversation better go ahead and terminate. Turn around and walk away. By law, you cannot talk real estate. And I don't care who, that person might be mama. If mama signed a contract with another agent, by law, you cannot interfere with another agent's agency relationship. That's illegal. But a lot of people will say, well, if I don't know it, then you can't hold me liable for something I didn't know. Okay, but you should have asked. Why didn't you ask them that? Now, I will tell you, there's been a number of times I've asked the question, are you working with another agent? And I kind of get a pause. Like, they're not sure if they're working with an agent or not. You get that a lot for whatever reason. But when I see them kind of hesitate, then I'll reword the question. I said, well, let me reword the question. Have you signed anything with another agent? And most times, oh no, we haven't signed anything. Reason they're hesitating, maybe they have spoke to another agent, they've gotten information or whatever. They never signed an agreement with another agent. If they've never signed anything, they're still a customer and they're still free game. So if you have not signed anything with anybody, then here, you can borrow my pen if you want to, but if you're getting ready to sign one now, if I'm going to help you, right? Get that, you got to get it signed. Get that agency agreement signed. The longer it takes you to get it signed, again, they're free game. Anybody can come and get them. So you need to get that agency agreement signed. All right, well, hopefully that makes sense about procuring calls. Hopefully you're good there. The second obligation they owe us is reimbursement. Now, what you want to be careful of here, a lot of agents misunderstand really what this means. But let me give you an example here. Say I'm talking to the seller, obviously, about listing and selling their house, and while I'm trying to convince them that I'm the best agent for them, obviously part of what you're going to do is tell them, here's what I do, and here's how I'm going to go about selling your house. And I'm going to do this, I'm going to do this, I'm going to do this, and you list all the things you're going to do to sell the house. Well, one thing you want to be careful of here, by the way, if you're saying you're going to do this, 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 and this, typically all these things cost money to do. Well, who pays for that? I mean, who's going to pay for all these things you're saying you're going to do? I will tell you, that's coming out of your pocket, not the company's. That's coming out of your pocket. So if you don't have the money to pay for some of these things, the marketing, advertising, all the stuff you say you're going to do, you better not say you're going to do it. Because if you say you're going to do it, you have to do it, and you better have the money to do it. But let's just say, just for example, it cost me $1,000. I'm just throwing out a number, making up a number. It probably won't be that much for most of us, most of you anyway. And I will tell you, I typically spend about $1,000 the day I list a house of my money trying to market and advertise and whatnot. But anyway, let's just say I'm already out of pocket $1,000 listing this house. And a few months later, we've got no offers. It's not under contract, and eventually my listing expires because y'all, you got to put an expiration date. Y'all, the law doesn't say how long it has to be, how long that listing agreement has to be for. It can be as short or as long as the parties would agree. But you must have an expiration date. It must state it will expire by this date if it has not already sold. So you have to have the date there. That's by law. Well, let's say my listing expired and the seller decides to list it again, but with a different agent. So, Frank, you had your shot. You didn't sell it. I'm going to give somebody else a shot. So they list it with somebody else. Well, if they list with somebody else, do they now have to reimburse me for what I've already paid or the expenses I've incurred in listing the house to begin with? No, they do not owe you anything for that. That's not what they're talking about here. Y'all, the only time this reimbursement applies is if, say, I spent the $1,000 and then a month or 2 months, and let's say I listed it for 6 months. I'm just making up a number. But say I have it listed for 6 months. But 2 months into it, the seller comes back and says, Frankie, we appreciate everything you've done, but the wife and I have been talking and we've just decided we don't want to move. We don't want to sell. We're going to stay right where we are. So we want to just take the house off the market. Well, y'all, if they decide to do that, y'all, there's nothing you can do about it. Okay? Therefore, it's their house, and if they decide to change their mind, don't want to sell it, they don't have to sell it. But wait a minute, I've done spent $1,000 trying to sell it. Now you're going to take the house off the market, and now I can't sell it? Well, now you have to reimburse me. So if the seller decides just to take it off the market, then they have to reimburse me for whatever my expenses are. But those expenses must be specifically addressed in the listing agreement. In other words, I got to put in the contract, I'm going to do this and it's going to cost this much. I'm going to do this and it costs this much. Y'all, if you didn't identify those things in the listing agreement, you're not going to be reimbursed for, or they're not legally bound to reimburse you. But that's what the reimbursement is talking about there. If that only applies if the seller decides not to sell. Okay? Y'all, if it expires, that's on you. Y'all, you said you could sell it within whatever time you agreed to, and you didn't do it. You can't blame the seller and expect them to have to reimburse you because you didn't do what you said you were going to do. So there you go. All right. Says our principal owes opportunity. Yeah, I think this should primarily apply to sellers. In some cases, buyers, but y'all, sometimes sellers can cause you a problem right here with the opportunity. And this is something you better be careful of, and you're going to learn one way or another. Sometimes you got to learn things the hard way to become educated, right? And this might be one of these things you're just going to have to live through it and learn the hard way, but you'll see what I'm talking about when you get out there and start practicing. But I've actually had, just to give you a couple examples, I've had sellers say, all right, well, Frankie, we've decided we want you to list the house. However, I don't want a lockbox on the house. Now, if you're not sure hopefully you know what a lockbox is, but a lockbox is just something typically hangs on the door handle, front door typically, and it's got a key to the house. And that way, any licensed agents that are members of the MLS, we all have like a remote, like a key thing, where we can open the lockbox, get the key to the house, open the door, and show it to buyers. That way, it's just a lot easier to show the house that way. Well, if the seller says, I don't want a lockbox, I'm going to tell you, that's going to cut down on your opportunity to sell the house. That's going to reduce your opportunity. Because basically what that means is, without a lockbox, that means any other agent that has a buyer wanting to see the house, that agent won't be able to get into the house because there's no lockbox with a key. So how are they going to get in? That means if you list that house, you're going to have to meet them there at whatever time, let them in, and typically you'll have to sit in your car. You can't be just following them around the house. So you're going to be sitting in your car waiting on them to get done, and when they get done, then you got to go lock the house back up. And then you can go back to your office wherever you're going. Then you'll find when you get about halfway back home or back to the office, you get another phone call from another agent, and they're wanting to show the house. Now you got to turn around and go right back. I'm telling you, that's a pain. That's a huge pain. I've actually had sellers try to tell me that they only want buyers to look at the house on a certain day at certain times. I'm just telling you, when a seller starts putting so many restrictions there, I'm telling you, that cuts down on your opportunity to actually sell the house. I've had another common one. Sellers say, I don't want a for sale sign in the yard. Now I get it. There are some neighborhoods that their restrictions prohibit signs in the yard. Now look, if nobody's allowed to have a sign, then so be it. But if other people have signs in the yard, then I want mine in the yard. Because I know, my sign is a pretty significant percentage of my business. I pick up more business by having that sign out there. So when you say I can't do some of this stuff, again, it's cutting down on my opportunity. So what I'm telling you to be careful of, be careful what you agree to. And it's when you're first starting out, I'm telling you, I've been there. You just want that listing. You want your sign in somebody's yard. I want a listing. The problem is you're so desperate for the listing, you'll agree to almost anything in order to get the listing. If you're not careful, I'm telling you, you're going to agree to some things that will prevent you from even being able to sell the property. Well, what good does it do to list it if you can't sell it? So y'all be careful about how they might try to limit your opportunity there. It says they owe us good conduct. Now, I will say this one applies almost 100% to the buyers. I'm going to tell you something. I don't know. Adults behave much worse, or certainly as bad, as children. And it's kind of embarrassing, but I'm telling you, you got to tell adults how to behave. It's unreal. Here's something that you really, really need to be careful of. Certainly as a buyer's agent. And I'm afraid, I know the buyers are not thinking about what I'm about to tell you. And what I'm afraid of is that I don't think many agents are thinking about this either. But I want to make sure you're thinking about it. If you're showing a buyer a house, you got to understand, you're not just showing a house. This is not just a commodity. You're actually in someone else's home. This is their private, personal space. They're allowing you to come in to look at it because supposedly you're interested in buying it. But when you're in someone else's home, this is not just a house for that seller. This is their home. And you have to respect that when you're in somebody else's home. Just for example, and you're going to get calls from your sellers, I promise you, when this kind of stuff happens. But say it's a summer day, it's hot, around South Carolina, it gets very hot during the summer. Excuse me. So we walk into the house, and maybe the homeowner, they like it warm. So they've got their thermostat set on 78, for example. So it feels kind of warm inside the house, and you're trying to cool off because you've been outside in the heat. And guess what these buyers will do? They'll go find the thermostat. They'll sit in the hallway or whatever and knock it down to 70 degrees, trying to cool it off. Or if in the winter time, they'll adjust it so it's warmer in the house. Have you lost your ever-loving mind? What right do you think you have to walk into somebody else's home and start adjusting their thermostat? That's just wrong. You can't do stuff like that. And to make matters worse, when they get ready to leave, they don't even put it back to where the homeowner had it. So now the homeowners come home from work or from wherever they are, and the temperature's 70 degrees inside here now. Now they're freezing because they're cold-natured. Plus, they got to pay extra money now because of all the electricity it took. But anyway, I'm just telling you, you're going to get calls like this, and it's just, it's crazy. I've actually had buyers, believe it or not, looking through dresser drawers. Why in the world? First of all, buyer, even if you buy this house, do you think that's going to include the furniture in this bedroom? No. Then what business is it of yours what's in any of those drawers? Why are you looking through drawers? It's not going to be here when you buy it. Leave it alone. Get out of there. My point is this. Do not let your buyers go wandering through the house alone. Don't let them do that. If you've got a couple, two buyers, husband and a wife, whatever, I tell them, you will not split up. We're all going to stay together because, we've had problems with this over the years, where you'll have like two people posing as a couple, and they'll have you go show them a house, and they will intentionally split up. One will go one way and the other one will go the other way. Well, obviously, you can't go with both of them. Well, whichever one is left alone, what they've been doing, they're going through cabinets, they're in the bathroom or wherever, but they're looking for prescription medication. They're stealing stuff. And God forbid the seller left some jewelry out on the counter or something like that. I'm telling you, they could just grab it, pick it up, put it in their pocket, and you'll never know it because you weren't with them. So, you've got to be careful about stuff like this. Talk to them, educate them if you have to, but tell them, there are some things that I expect here. And one, you will not be out of my sight. Neither one of you, nobody. We're all going to stick together. And if one of them starts to walk off, I'll tell them, come back here. Get back. Just like you have to do a child. Get back. Get back here. Anyway. I hate that I have to treat adults like children, but I'm telling you, you have to do that a lot of times. So, anyway, they got to behave themselves. Says they owe indemnity. Now, what they're talking about here is, in fact, one of the things I tell every buyer and seller, anybody I'm representing, I tell them, if you have any questions or not sure about something, don't understand something, call me. If you want something done, call me. Let me handle it. That's what you're paying me for. Let me handle everything. Do not go out there on your own and start making calls or doing, whatever. Don't do that. Let me handle everything. You communicate with me and me only. That's what I tell my clients. Now, after saying that, could they still go out and call somebody, the other party, or trying to convince somebody to do something or whatever, and I don't know about it? Yes. Well, what this indemnity is saying is this. Seller or buyer, if you go out there and do something or say something on your own and you wind up getting yourself in a mess over it, then you need to understand, seller, you're in a mess, not me. You did it, not me. So indemnity means you can't try to blame me or sue me for something you did. Right? Y'all, that's indemnity. Okay. And then good faith. And I think this one primarily should apply to buyers. But, if you come up to me, buyer, and say that you're wanting to buy a house, then I expect you to buy one. And I will tell you that's not the case for all buyers. Believe it or not, you'll have people say they're interested in buying, they're looking for a house, and have no intentions of buying a house, or certainly not anytime soon. Y'all, that's not operating in good faith there. You're wasting a lot of my time, effort, resources, and you have no intentions of buying a house. Y'all, for example, y'all have people, in fact, I've learned, y'all, the second question I ask, but we know the first question, we always ask a buyer, are you currently working with another agent? The second question I got is, when do you intend to buy? When are you looking to actually buy something? And a lot of times what you'll hear, y'all, let's say it's October right now. And I asked this buyer, I said, well, when are you thinking about buying? When do you think you're actually going to buy something? Well, I live in an apartment right now, and I've got a lease, and the lease, there's still 7 months left on my lease. But as soon as the lease is up, then I'll be buying. Okay, well then how about call me back in 7 months? You're not wasting my time right now. But you'll have people like that. They just feel like they can just waste your time. They know they can't and are not going to be buying now or anytime soon. But they think they might want to buy it, maybe next year sometime. But you've got nothing else to do you? Can't you just show me some houses and let's just go shopping? Y'all, I hate shopping. I am not shopping. If you're ready to buy, show me the money, and then we'll go buy. But y'all, to me, that's what acting in good faith should be all about. All right. So those were the obligations that we owe, that the principal owes back to us. Now we're looking at what are the agent's obligations to customers. All right. Now I've got a couple slides here, and this first slide is showing the services that agents may provide. Y'all, these are things you may do for a customer. Now, remember, if you're working with a customer, by law, all you can provide to that customer are administrative type services. Okay? Y'all, and I keep trying to throw that ministerial out there because you're going to see that again. That term, ministerial acts or ministerial services. So the things you see listed here that we're about to go over are considered ministerial in nature. The first one says you can show properties for sale, or if they're looking to rent a property, for lease. Again, y'all, can I show them a property without providing professional service? Y'all, is that a professional service? Y'all, no. Y'all, if that's all you're doing. Now, I will tell you where you got to be careful. Y'all, there's a thin line for all of these things. And you can cross over the line and get yourself in trouble. So obviously it says you can show properties for sale. Now, where you could get in trouble is while you're showing the house, they're asking you all these questions or asking you what your thoughts are on certain things, and you start providing your opinions. Now you've crossed the line. Y'all, now you're giving that buyer reason to think you're representing them. Right? So, y'all, don't cross the line on any of these things it says you can do. Number two, you can provide statistics and information on the property. Y'all, what they're talking about there would be like things that would be considered public knowledge. For example, and a very common question a buyer might ask you, Frankie, do you know how much the property taxes are for this property? That's a very common question. Well, I've just learned that I know that that's probably going to be a question. So one of the things I always do before I go to any property is I print out the tax card. You can go online and just print it out. And then when they ask me that question, I can say, well, I can tell you what the taxes were last year because it's on the public website, right? You just provide that information and then that's it. Zip it. I ain't going no further than that. Then it says we can provide pre-printed forms and contracts. So if your customer says they want to make an offer on the property, can you provide them with a copy with the documents they might need to make an offer? Sure. There's nothing professional about that. But where you get into trouble is when they go to try to fill out the offer, they don't understand or they're not sure what this is asking for. Well, Frankie, what does this mean? I'm not sure what I'm supposed to put here. Okay, well, can I answer that? No. That's a professional service when you start telling them how and what to put in the offer. Again, if you're saying you want to be a customer because you know what you're doing, then why are you asking me? Why do you need my input if you're going to do it yourself? So I'm not going to do that. So again, there's a very thin line on what you can do here. But you cross over that line, now you're getting yourself into trouble. It says you can act as a scribe in preparing the form. So in other words, I can actually write up the offer, but buyer, you got to tell me what you want me to put here. Well, Frankie, what do you think would be the best? I can't answer that. You tell me what you want here and I will write it up. I will write up exactly what you say. I'm not going to take away or add to it. I'm going to put exactly what, that's what a scribe does. They just write up what they're told to write, and that's it. Go any further, you got a problem. It says we can identify settlement service providers. Settlement service providers, or sometimes you call SSPs for settlement service providers. This would be anyone that's providing a service in connection with the transaction. It could be the attorney, could be a lender, could be a home inspector, termite inspector, you name it. Anybody providing a service in connection with the transaction is a settlement service provider. What you're talking about here, and this is pretty much every single time, especially with buyers. Obviously once the house goes under contract, the next thing we probably want to do is get a home inspection done. So I said, well, buyer, I assume you want to get a home inspection. Oh, yes. All right, buyer, who would you like to choose? It's always the buyer's right to choose anybody they want to use. Nobody can tell that buyer who they have to use. Nobody. And if anybody tries to tell them they have to use a certain provider, that's illegal. By law, it's the buyer's right to choose any service provider they want to use. So I have to ask them, buyer, who would you like to use to do the home inspection? And typically when I ask that question, they're like, well, Frankie, I don't know any home inspectors. I don't know anybody. I don't know a lender. I don't know an attorney. I don't know an appraiser. Whatever. Can you refer somebody to me? Can you suggest somebody? There's nothing wrong with that. Okay? So, if they ask you for a referral, sure. In fact, here's three. Here's 3 home inspectors. Here's 3 attorneys. Here's 3, and then choose. Let them choose whoever they want. There's nothing wrong with that. And then lastly, it says you can also identify where schools are, shopping centers and stuff, things of that nature. For example, the buyer might know because they saw it in the MLS where this school is zoned for such and such an elementary school. So they know that. The problem is they don't know where the school is located. Where is the school? Well, y'all, again, that's kind of public knowledge, and assuming you know where it's located, you can tell them where certain things are. So those are not considered professional services. These are all considered ministerial services as long, again, as you don't cross the line with any of these things. Be careful with that. So again, these are the services that you may provide. Y'all, these are in the law. Now, the next slide you're looking at is what the law is saying here is if you agree to work with a customer, then here are some things you must do. Y'all, these are not optional here. So again, if you agree to work with them, then you must do these things. Y'all, obviously, number one, you must timely or promptly present all offers. Y'all, you can't procrastinate or hold off on that. Y'all, if that customer says, let's go ahead and make the offer, then you got to go ahead and present that offer. Obviously, you have to account for any monies, again, that you take control of. Again, provide these forms and contracts. But, y'all, that next, the last one here, what is that, number fourth bullet, I guess. Provide an explanation of services provided. Y'all, probably in the next hour, but, y'all, you have to disclose agency, okay? Y'all, you got to disclose to buyers and y'all, to any principal that you might potentially be working with. You got to disclose that they've got a right to be represented as a client and make sure they understand what services that would include. Or they could choose to stay or remain a customer and make sure they understand what they get and, more importantly, what they don't get if they're a customer. So you got to make sure they understand what they're agreeing to here, okay, in terms of becoming a client or staying a customer. And then it says you must always be fair, be honest, and provide accurate information. Y'all, again, just because they're not your client don't mean you can lie, steal, mislead, stuff like that. That would be a no-no. All right. Some other disclosure requirements. Property defects. Y'all, we've talked about that 2 or 3 times already. Excuse me. Y'all, if you have knowledge of a defect, something wrong with the house or something wrong with the property, do you have to disclose that? Yes. Y'all, if you have knowledge of it, you must disclose it. Now, y'all, what they're going to likely try to do to you on the exam, y'all, and it's just the way they word it is what you got to be careful of. Because, y'all, they'll ask something, they'll ask it in a way that makes it very clear that for clients, you absolutely must disclose known defects. But if they're a customer, do you really have to disclose it for customers? Yes, absolutely you do. Yeah, the law says it does not matter if the buyer is a customer or a client, seller and or their agent. If you have knowledge of any problems or defects, you must disclose it. And again, that's a written disclosure. Y'all, one of the things, if you hadn't already figured this out yet, there's no such thing as a verbal disclosure or no legal thing. Y'all, if it's not in writing, whatever disclosure you made, if it wasn't in writing and they signed off acknowledging it, then you didn't disclose it. Y'all, you can sit there and tell that investigator all day long, but I told them. I told them over and over again. If it's not in writing, you didn't. Nope, not going to happen. Y'all, and then the other thing it says here you have to disclose is what we really just talked about earlier. Y'all, the agency relationships. Y'all, the difference between a customer and a client. What you can do and can't do for either one. Y'all, all of that must be disclosed. Yeah, and then it kind of touches on these limitations. Y'all, again, we beat this up. Remember, you are very limited on what you can do for a customer. You're very limited. No professional services whatsoever. But y'all, if you do anything or say anything that would have the principal believe you're representing them, you're their agent. Y'all, what have you now created? Implied agency. And we already talked about this too, but we know implied agency is illegal. Okay? Don't go there. Y'all, you will get in trouble over that. So just be careful with that. So, y'all, those are the obligations that we owe to parties, that we owe to clients, also some we owe to customers, and what clients and or customers owe back to us. But by the way, what does the customer owe back to us? Nothing. Absolutely nothing. Y'all, does that sound like a relationship you want to get into? Where you owe them, but they don't owe you anything. That's not the one I like. But y'all, again, be clear. Y'all, can you legally work with a customer? Yes. Now, if you're working with a customer, what does that make you? Y'all, just kind of reviewing real quick. That makes you a transaction broker. Are transaction brokers legal? Yes. As long as you don't do or say anything that would give that buyer or seller reason to think you're representing them. Because if you do, that's where the implied agency comes in, and you're going to have a problem. Okay? Y'all, for me, I pretty much only work with clients. Now, that doesn't mean you can't work with customers. I'm not trying to suggest don't work or you can't work with customers. It's just a policy, I guess, of mine. Y'all, if you're not going to make a commitment to me, then I'm not going to make one to you. I don't work that way. I don't. So anyway, those are the obligations that we owe to the parties.